Typically, when we think about regulation of legal services, we think about regulating lawyers, ethics rules, and other kinds of regulations regarding lawyers and how they do their work. But increasingly, we're seeing other kinds of legal services providers who are delivering legal services to the public. And the question that has been raised is, to what extent should these other providers be subject to regulation as well? In some parts of the world, including some parts of the United States, the reaction to these new providers has been to try to prevent them from operating, to say that they are engaged in the unauthorized practice of law. I believe that that's a mistake. But on the other hand, the opposite extreme, I believe, also could be a mistake, which is to allow these service providers to deliver many kinds of legal services without any regulation at all, except perhaps lawsuits based on negligence. So the idea of my paper is to think about the law of legal services generally, which includes not only the regulation of lawyers, but the regulation of other kinds of legal services providers as well, and to come up with a framework and a set of principles that would guide our regulation of these of the legal services providers, lawyers and others as well, so that we are all subject to very similar kinds of principles. That's the idea of my paper.
Yeah.
It's a very important foundational question about how technology can be used to resolve disputes and whether society and people will accept the resolution of disputes when technology is involved. So during my presentation, I was describing a system in the US that was used for eBay to resolve disputes between a buyer and a seller. And it created an automated question and answer process that ultimately leads to a resolution without a human being involved. And now those kinds of systems are being used by courts all around the world, Canada, the UK, increasingly the United States, to allow people to resolve their disputes through an automated process that does not require a visit to a court. On the one hand, this can be very beneficial. People sometimes don't want to go to court, or they are concerned about going to court for one reason or another, or it's very inconvenient, or the amount at issue is such that going to court, it doesn't make sense, or to hire a lawyer doesn't make sense. If you can create an automated process for resolving disputes, you might be able to have people more effectively served in terms of justice and the rule of law. On the other hand, if you have these systems that are largely automated, resolving disputes, will people accept the outcome of those cases when there is an algorithm or a decision tree and not a human being deciding what the result should be? And I think the answer is that it depends. It depends on the area of law. It depends on the type of dispute. But I do think that there are a large number of very routine legal matters that are brought to our court systems that can be resolved in much more automated ways, and that the public will accept and find it beneficial to be resolved in a more efficient manner. So I think that the answer is complicated when it comes to justice, and it will be important to really understand where we should use technology and where we should not.